Good evening and welcome to the Town Hall on COVID and Criminal Justice. My name is Mike Heminger and I'm the Democratic Party representative. On behalf of the Arlington Young Democrats, I'd like to welcome you to tonight's Town Hall. If you have questions you'd like us to answer, we invite you to drop your questions in the chat below. Joining us tonight, we have Commonwealth Attorney Parissa Tafty and Delegate Jennifer Carroll Foy. Parissa Degani Tafty has working to reform the criminal justice system as a public defender, an innocence protection attorney, and a law professor. As a public defender, Parissa litigated cases of systemic and constitutional issues, advocated to eliminate race, class, and gender bias in criminal proceedings, represented clients in parole proceedings, and obtained the very first DNA exoneration in Washington, D.C., which led to the discovery of false testimony by an FBI analysis and resulted in the FBI reviewing thousands of past cases. As the legal director of an innocence protection organization, Parissa worked to exonerate individuals wrongfully convicted of crimes they did not commit by investigating and solving decades-old cold cases involving serious crimes such as murder, rape, and arson. As a law professor, Parissa has authored a law review article demonstrating the need for meaningful national reforms to ensure the reliability of criminal convictions. Parissa was elected this past November to serve as the Commonwealth's attorney for Arlington and Falls Church. Good evening and welcome, Parissa.
Hi, it's a pleasure to be here.
Thank you. Jennifer was one of the first African-American women to graduate from VMI. Having spent 4 years at Virginia Military Institute, Jennifer learned to address problems head on and never back down from a fight. After graduation, Jennifer went on to receive a master's degree from the Virginia State University and a law degree from the Thomas Jefferson School of Law. Jennifer started her career as a magistrate judge and then became a public defender to help give a voice to the often voiceless, including children, people suffering from addiction, and those experiencing homelessness, those with mental illness, and the poor. In 2017, she took her commitment to service to the Virginia House of Delegates. She led the charge to clean up toxic coal ash ponds across the Commonwealth and voted to expand Medicaid for 400,000 Virginians. Jennifer was reelected in 2020 to the 2020 General Assembly, where she championed a pro-woman, pro-labor, pro-environment agenda and was the chief sponsor of the Equal Rights Amendment. Jennifer is also a gubernatorial candidate and would be the first woman governor in Virginia and the first African-American governor in the United States. Delegate Jennifer Carroll Foy, welcome.
Hi, thanks for having me.
All right, let's go ahead and jump right in. We're going to start the conversation about discussing COVID. So what can all stakeholders and criminal justice actors do to ensure only the people that need to be in jail are currently in jail? Parissa, we'll start with you.
Thanks, Mike. Well, we're really lucky in Arlington because pretty early on, Brad Haywood, the public defender, Sheriff Beth Arthur, and I got together and recognized that what we really need to do is thin out the jail population in order to make sure that we could sort of reduce the numbers of deputies that were in the jail and also reduce the number of people so that folks could be spread out more and so that folks who needed medical care could get medical care. And, you know, we just started getting lists of folks who were locked up, and we started looking at people who had gotten cash bail, even though my office doesn't seek out cash bail. The previous administration had, and there were people who were sitting in jail who had not been able to afford to pay their bail, and the judges were still imposing cash bail. So there were a number of people that we initially looked at who just hadn't, who had $15,000 or less bail amounts, and they just couldn't get out because they couldn't afford to pay them. So we started letting those folks out, and we were proactive and called defense attorneys and said, you should file a reconsideration in this case. We'll support it. Now that we're down the line a little bit, we should be looking at DOC folks and starting to try to thin out the populations. And what we're looking at is, sort of how long ago was the crime? Was it violent or not? Is somebody in for a probation violation? Because there's a lot of people in prison on probation violations. And what kind of probation violation was it? Is it a new crime, or is it, failing to show up or failing a drug test, a few drug tests? So we're trying to thin out the population in that way.
Thank you, Parissa. Delegate Carol Foy, what has Governor Northam done to keep folks out of prison?
Governor Northam has encouraged for the Supreme Court to direct all courts and judges to utilize the tools that's already available to them to promote any changes that can be done to reduce the prison populations. So, for example, encouraging motions for reconsideration or suspension of sentences, ensuring that people who have show causes or who otherwise would be taken before a magistrate or given a bond motion or bond hearing would now receive summonses, so they can just be released and not taken to the jail. Promoting diversion, so people who are really having mental health crises are directed to treatment and programming instead of being taken down to the jail. And so all of these things are helping. I think that there's still more to be done. We can be bolder. And some of the ways that we can advocate to reduce prison populations to really ensure that the most vulnerable Virginians don't contract COVID-19 is by reaching out to Governor Northam, Secretary Thomason, and Secretary Moran, and asking them to promote more policies that can reduce the prison population, such as entrusting the parole board to expedite reviews of cases. And because when you do that, then you can actually release more people who should be on geriatric parole, because those are some of the most vulnerable people in our prison population. So we all know that jails are incubators for COVID-19, and jails, some have substandard medical care and aren't equipped to be able to take care of people who have come in contact with COVID-19. And it's almost close to impossible to really social distance in an effective way. So not only reaching out for there to be expedition of reviews for discretionary and geriatric parole, but also promoting clemency and pardons, because that's within the governor's authority and ability to do, especially those people who don't have long to serve on their sentence or people who are very susceptible to catching COVID-19. Some people even say, we'll take nonviolent offenders, whatever you can do, so people don't have to risk dying in jail or contacting a deadly virus. So those are some of the things that you can do to help ensure that we reform what we're doing now by promoting policies that make sense to reduce prison populations.
Thank you. Is there anything more or anything that we're not doing that would help prevent the spread of COVID in the jails?
For me?
Sure.
Okay, pressure for me. So to prevent spread in the jail, you can issue a show cause instead of issuing a capias. A capias is a bench warrant to be arrested. A show cause is basically another charge for potentially not doing something that the court directed you to do. And so instead of dragging people to the jail and risking them having a no bond or a high bond that they can't afford, releasing more people on summonses, especially if they're not a flight risk or a danger to themselves or the community. That's something that we can do. Also, I would say, really advocating for, I think a lot of Commonwealth attorneys, especially in Northern Virginia, have done a great job at this. They haven't waited for court-appointed counsel or public defenders or defense attorneys to reach out to them. They're looking to see which populations they can support being released early, whether you have 30 days or less to serve on your sentence, whether you are uniquely susceptible to COVID-19, if you're a nonviolent offender. And actually, like Parissa was saying, encouraging motions to be filed for modifications of sentences so people can be released early to reduce prison population. So I think encouraging more Commonwealth attorneys and judges to do that, I think it's great. I think we're doing a wonderful job in Northern Virginia and just, promoting that throughout the Commonwealth.
Thank you, Delegate Carol Foy. Parissa, many people accused of crimes don't have reliable internet or phone service, In some jurisdictions, courts have been penalizing defendants for not attending mandatory virtual court sessions despite this reality. How have cases been proceeding during COVID? And then have you been holding virtual status conferences yourself?
I mean, I can't speak to other jurisdictions. What I can say is that our courts have not done that. They have had very liberal continuance policies. Without talking about it, it seemed very clear early on that they were not going to penalize folks for not wanting to or not being able to get there during this crisis. We have tried to move a little bit more towards virtual hearings. I don't think that we're quite there yet, technologically speaking. We've done just a couple of things, including folks appearing on FaceTime for pleas in a couple of cases. But those are really more appropriate for cases where somebody's receiving a suspended sentence or no sentence of active jail time. You really have to be careful when when somebody is taking a guilty plea to something that carries a prison sentence or a lengthy jail sentence, because the court really needs to know that they're doing it knowingly and intelligently, and that's a little hard over the video when defendants can't speak to their clients or to their defense attorneys in a confidential way.
Thank you. Delegate Carol, are you seeing similar situations, or are you seeing different in other jurisdictions in Virginia?
As far as, I'm sorry, my
Sure.
internet paused for a second, so I didn't get all that question.
Yeah, no problem. Many people accused of crimes don't have reliable internet or phone service. In some jurisdictions, courts have been penalizing defendants for not attending mandatory virtual court sessions despite this reality. How is this being handled in your local jurisdiction?
So my local jurisdiction is Prince William County, and the judge has issued an order encouraging as many teleconference hearings as possible. And so we do have opportunity of needing to modernize our technology at our courts here in Prince William County, but they are definitely encouraging for that to be done. Because there's been a outbreak of COVID-19 here in Prince William County, there was a new order that was issued that defendants will not be brought over for their hearings, trials, etc. And so everything will be done remotely. That presents different challenges, but given the fact that there is an active outbreak, I have clients that tested positive for COVID-19. I think that is a measure that the judge thought was prudent to take advantage of. So I think there is a place for teleconferencing, especially when we are encountering such a deadly virus. And this is new trying times that we've never experienced and seen before. I do think sometimes that we do have to take innovative and creative measures in order to keep the majority of people protected.
Thank you, Delegate Carol Floyd. Parissa, as a result of the lockdown, many people are trapped at home with abusive partners. Some groups have been more severely affected by COVID-19 than others. This is often a result of existing inequalities that the current global crisis only exacerbates. One example involves domestic violence. What does the data currently tell us about domestic violence in light of COVID?
So going into this at the beginning of March, I would have told you that we were going to see a huge uptick in domestic violence cases. And we didn't see that. And that actually concerns me a lot, because we know that people are very stressed out, and what seems to be developing is a situation where the victims of domestic violence are so fearful and so unable to get a way that they're having trouble actually reaching out to services. Anecdotally, I think that the police number in Arlington and the city of Falls Church got a number of DV calls. But what we've seen is sort of like something more spectacular, like a shooting, for example, but not the steady pace of domestic violence cases. And again, that's not because they're not happening. I think that's because people are terrified to report right now because services are reduced, and they're more closely monitored by the abusers. We do have a great organization in Arlington, Doorways, that is there and is there 24 hours, and they are still serving. They are trying to do an incredible amount of outreach to make sure that there are safety zones, and to make sure that there are codes that victims can use, whether they're men or women, to report that they need help. But I don't have a lot of hard data. What we have is right now anecdotal and conjecture.
Thank you, Parissa. Delegate Carol Foy, I'd like to open that same question up to you. What does the data currently tell us about domestic violence in light of COVID?
Yes, I would like to piggyback on what Parissa was saying. I mean, we just don't have accurate data at this point. Many people who are suffering from domestic violence and sexual violence, they're not in positions necessarily to report it, because the last thing you want to do is be ordered to shelter in place with your abuser and then have law enforcement officers showing up asking questions. So I do anticipate that there will be an influx or increase of complaints after COVID-19 has subsided and people are able to go to the magistrate's office and file criminal complaints or openly talk to law enforcement officers. But right now, I think people's number one concern is keeping themselves as safe as possible. And so I know that there's some jurisdictions who are trying to get creative in how people can report and file complaints. Many jurisdictions have said that they want to do it online so people can be at their laptop and file a criminal complaint. They'll be taken up by police and then eventually given a court date, instead of having officers come out or you having to risk your safety and go out to make a report to a magistrate's office. So there are different things that's in the work, but right now we don't have the accurate data and the accurate reporting because of the unique circumstances and situations that COVID-19 has presented.
Thank you. Parissa, how has COVID and all the societal inequities it has uncovered influenced how you might pursue criminal justice going forward?
I mean, I'm hoping that we will learn some philosophical lessons from COVID, because if somebody is safe enough to let out during COVID, then why would they not be safe enough to let out under normal circumstances? And so I'm hoping that, we'll really see that, make sure that people have support systems, and making sure that, and releasing people on supervision or on their own recognizance or with other measures. I mean, we've released people on electronic monitoring, we've released people on house arrest, and hopefully the lesson that we'll learn from all of this is one that we can still be safe and decarceral.
Thank you for helping us unpack that very important topic. We're going to switch gears and talk about some of the reform that we saw in the General Assembly. First question goes to you, Delegate Carol Foy. Various bills were introduced regarding the legalization or decriminalization of marijuana. Ultimately, the decriminalization bill succeeded. My first question is this enough? And could you talk to our viewers about what the difference is between decriminalization and legalization?
Great question. And so I carry the legalization of marijuana bill. And so to answer the question of whether or not I think decriminalization goes far enough, my answer is a resounding no. Statistics show that decriminalization of marijuana will not impact disparate number of African Americans being stopped, charged, and convicted for possession of small amounts of marijuana for personal use, although their usage rates are almost exactly the same as their white counterparts. And so decriminalization inequity. So legalization and many others, because we understand that in order to really address the racial inequities in our criminal justice system, we have to look at the policies that's in place. And so Virginia can join the multiple other states who have legalized marijuana, because my bill had nothing to do with distribution. It was simply to legalize possession of small amounts of marijuana for personal use, period. do tax it and generate revenue here in Virginia to help house our homeless, help with affordable housing opportunities, fully fund our pretrial services, so that way this and substance abuse can actually be diverted and we can fully fund those programs. But it's just the right thing to do. And I know that a lot of legislators like to move at an incremental pace, but now is the time for bold policies to really address a lot of the inequities in our system. And a lot of these inequities have been exposed by COVID-19 in a multitude of ways. So I look forward to continuing to champion legalization of marijuana and hopefully getting it passed in 2021.
I'm just going to second that. Everything Delegate Foy just said.
Thank you, Perissa. I actually have a question for you. How does this, or what does this bill mean for those who have previously been charged with marijuana possession in Arlington?
So it actually means nothing. What the decriminalization has not affected folks who have in the past been convicted. Some of the legalization bills, most of them had an expungement piece to them, which would have gone back and cleared the records of simple marijuana possession. And I completely support that. You know, the collateral consequences of a simple marijuana possession range from not being able to get Pell Grants to not being able to get federal housing assistance. And you know, what it really does is it digs people deeper in a hole, and it takes away any potential ladders or ropes that they had to climb out of that hole. So I just think we have a lot more work to do. And I think it's important to note that legalization doesn't mean that you're going to have, you know, like a marijuana stand on every corner. We can legalize and we can regulate. And, you know, we can regulate to the extent that California has done, and make sure that people who have been the most adversely affected by the previous marijuana laws are actually the ones who have priority in creating getting dispensary licenses. And so we can do this in a way that creates equity and tries to repair some of the harm that's been done.
Thank you. Just a follow-up question on that. What work needs to continue to happen in order to make sure that the legalization bill passes in 2021?
Is that for me?
Yeah.
Okay. All right. So we need to lobby. So advocacy is the best antidote for our problems, especially when we're not getting bills that's important to us passed. And so it's about calling your legislators and letting them know that this is something that's important and you want this policy passed and you want it passed now. And if they don't agree, ask them why, because oftentimes it's rooted in misinformation and fear mongering. And so a lot of people have the tough on crime mentality where we know that we have lost the war on drugs many times over, and that you can't incarcerate yourself out of addiction. And so that's not the issue here. The issue is, how do we move Virginia forward in a reasonable and responsible way? And legalizing marijuana is a step towards doing that, to combating a lot of inequities, especially racial inequities in our systems. And this is one of the policies that does that, but also doing it that makes sense for Virginia. And we're ready. We can have the systems in place. We've done the research. We've looked this over many times before, and we're on the way towards a majority of states in the country actually legalizing marijuana also. California, like Perissa said, is a great example of doing it in a responsible way, to where children don't have access and it's illegal for them to have it. And that is just for legalization personal use. In my bill, I did an expungement part in there that allowed for the expungement of people's records. The decriminalization bill just had a sealing of records, which means that there's still access. And so that's still a problem. And so while I think for some people,
Thank you, Delegate Carol Foy. Your internet kind of cut out, so I wasn't sure when you stopped.
I know. I don't know what's going on.
Technology, gotta love it. All right, another bill regarding juvenile criminal justice reform that passed prevents students from being arrested for or charged with disorderly conduct at school or during school activities. Parissa, how does this bill change the way that schools deal with discipline issues?
Well, I'm hoping that it will cause fewer referrals to the criminal legal system, and that, in combination with the restorative justice that we're starting up in Arlington, we will take a different approach to school discipline. If a kid punches another kid, that's assault, right? And that's an actual crime. Disorderly seems to be present for when, and it is for when you can't really fit behavior that you don't like into an actual crime category. And now we're at a place where, if you're in that gray area, it really, the law now says, that you shouldn't be referring these people to these kids to the criminal legal system. And, in combination with the work that we're doing on restorative justice, I'm hoping that we will really be able to tackle school discipline in a way that encourages people seeing each other's humanity and dignity, whether it's over racial lines or whether it's over, adults versus kid lines or whether it's class lines. And I think that sort of closing this off is sort of like built a dam, and now we can sort of redirect the water into a place that's more productive.
Thank you. That's awesome. Delegate Carol Foy, the 2020 General Assembly was historic on all fronts. In your opinion, what was the biggest criminal justice reform success in 2020, in your opinion?
Hello?
Hey.
Can you hear me?
We can hear.
Sorry. Internet again. I apologize. I know we froze. And so I think I heard most of the question, but first I like to say I love hearing Parissa speak. It is like a breath of fresh air on a summer day, and it just warms my heart to hear her perspective. And it's just amazing. And so I am a super, super fan of Parissa Tafney. So I just wanted to say that before we ran out of time. And so, yes, this was a historic legislative session, and we made huge progress on many fronts. As far as the criminal justice reform front, I have to say that a lot of the bills that we passed make good sense. And so increasing, again, the minimum wage to where Virginia went, the minimum wage, but the grand larceny threshold. So increasing the grand larceny threshold in Virginia, where we left from being mid to lower in the country to now, mid to higher threshold. So making sure that the punishment fits the crime, and a person who maybe takes a phone should not be considered a felon, just like a person who rapes, murders, and robs, right? And so just making sure that we have policies that make sense. One of the things that we did not get done that was regrettable to me is something that would really change the way that we do jury trials here in Virginia, that's rooted in equity. And that is ensuring that you don't only have to have jury sentencing. That is huge. I can't tell you how many clients I have to have the conversation with them, and they say, Jen, I didn't do it. And I say, I believe you, but I'm not willing to risk 3 or 5 years of your life on it. Right? And so it sometimes forces the conversation of a potential plea where there shouldn't be one, because everyone should have, freedom and access to having where juries don't have the privilege of having the privity of sentencing, guidelines like a judge would. Hello, there you go. Okay. Yeah, and so I don't know where I stopped. Where'd you guys finish hearing me at?
They don't have the privity.
Okay. They don't have the privity of having the sentencing guidelines to determine what is fair and appropriate for that defendant. And so that's a real problem. And so where we would have a judge trial, and potentially my client could be found guilty and only get maybe a year in jail. If we take it before a jury, which I think, in my opinion, we might do better, I also have to risk higher punishment for my client. And so we actually had, during the hearings in Richmond, a Commonwealth attorney stand up and say, we don't like this Joe Morrissey bill that will eliminate mandatory jury sentencing, because then more defendants will ask for jury trials, and that will mean more work for us, and that will clog up our criminal justice system. And my response, and Delegate Don Scott's response, who is also a criminal defense attorney, is that's the way the system is supposed to work. That is a constitutional right that is entitled to all defendants because they have not been found guilty of a crime. And so to know that there are some Commonwealth attorneys out there with the thought process that we want to be able to have a weight to hold over a defendant's head to, boss and bully them into a plea that they otherwise would not and should not take is a problem. And so I think for me, that would have been one of the most revolutionary bills, most impactful bills that we could have passed this last General Assembly. And I look forward to continuing to advocate for that.
I just want to jump in and say that legislators to pass that.
Awesome. Parissa, in your previous response, you mentioned restorative justice, and we've been hearing a lot about restorative justice in Arlington lately. And could you help our viewers understand what the principles and practices of restorative justice are?
So the best way the easiest way, I think, to describe restorative justice is in contrast to retributive justice. And retributive justice asks, what law was broken, who broke it, and how do we punish them? Whereas restorative justice asks who was harmed, what do they need to heal, and who's responsible for that healing. And so it's a victim and survivor centered approach that allows victims and survivors to have a great deal of autonomy in what happens to their case and what they need to heal, and to have a lot more control than they have now, because despite the fact that we have statutes that delineate the rights of victims, a lot still don't feel heard. And the healing process doesn't really start for many of them until after the case is over, which is really, 1, 2, sometimes 3 years after the incident happened. So what it does is it shifts the focus more towards victims, but it also does this. It recognizes the humanity and the trauma of the person who did the harm as well. And, in doing the work that they need to do to heal, and in doing the work that both sides need to do to have empathy for each other, it really transforms the person who did the harm in most cases into somebody who won't do that harm again. And if you look at the studies and the meta studies, you see that, the recidivism rate drops down, sometimes 20 percentage points when restorative justice is used as compared to other diversion, and even more than 20 percentage points when it's compared to sort of the retributive justice. Because we talk about, accountability, but being locked up in a jail cell or a prison cell is a very passive kind of accountability. and restorative justice really requires people to have an active role in healing the person that they harmed. And that, to me, is real accountability.
Thank you. Delegate Carol Foy, do you have any experience with restorative justice? And what are your thoughts on comments?
So I co-sign on everything that Parissa said, and it is totally accurate. And, we have this very much retaliatory, punish, tough on crime mentality that's plagued our Commonwealth for far too long. And so if we're really going to have accountability, and if we're really going to ensure that we reduce recidivism rates, it really is about taking a fresh new outlook on how we address criminal justice and defendants. Because I oftentimes tell clients, right, sometimes the only difference between, that judge or that prosecutor and you is that you got caught. Right. So the idea that people don't make mistakes, and the fact that and the thought that people aren't defined really by, a bad day or something that was done. I mean, that's how we really have to look at this, and providing people with the support systems and all of the things that they need in order to be successful and make it out of the criminal justice system. Because what I tell people is that they're coming back to the community. You're not housing them in jail forever. So they're returning. The question is, how do you want them to return? Do you want them, better situated, or do you want them in a worse situation than when they went in? Because I can guarantee you that will be the same person that, will commit the same crimes. Because oftentimes these are people where their families have failed them, schools have failed them, the system has failed them. And then they end up with, me. And it is my job to fill in those voids as much as I possibly can. So it's always about accountability, right? And so we're not saying that people should not take accountability for what they did, but it's a way to do it that's responsible and that's respectful of people and their issues, and that they come to me uniquely, traumatized or challenged by different issues. And so that's what it really means for me, because when you look at a community, show me how you treat the most vulnerable, and that defines who you are. And I think we have a long way to go in Virginia. But I am excited by the changes that's happening. I'm excited by the Commonwealth attorneys that we have newly elected in Northern Virginia, who are doing a phenomenal job and bringing a new perspective on how we address criminal justice and the reforms that we need, and how defendants should be treated as human beings and people, and not just as people who have moral failings or the undesirables. And so it makes my lift and job a lot easier in the General Assembly to pass policies that will help and reinforce these Commonwealth attorneys who are doing wonderful jobs and who believe in restorative justice, and not just their job is to penalize and punish by any means necessary.
Thank you. I loved your comments on that, especially around the most vulnerable in our community. As we transition out of restorative justice, I got one last question before we switch it over to our viewers. But I just want to remind everyone, if you have a question, we invite you to drop your question below in the chat. Parissa, what bills should we keep an eye out for next year? What are some of the things that you think we should be going after? And then Delegate Carol Foy, I'm going to ask you the same question.
We got to try again on some of the things that we didn't get passed this year. A lot of them were quite revolutionary, and maybe the second time around, people will be a little bit more inclined to hear. I was actually just making like a wish list myself of bills. And I'm definitely going to be calling Delegate Foy to carry some of them for me. But I would like to see legalization. I would like to see the judge option for sentencing. I would like to see the banning of some things like armor-piercing bullets, because I don't think anybody needs them unless they're planning on killing police officers or soldiers. I would like to see good cause better defined it's statutorily defined. It's defined by case law, by what it is not. But it would be nice to see good cause defined sort of actively. I'd like to see a wage theft that statute that is a felony, so that we Delegate Foy talked about the most vulnerable. When you talk about undocumented immigrants, and when you talk about people who are being exploited, when construction companies and large corporations and labor brokers, promise to pay them something and they don't, and they go to the non-union labor so that they can exploit it. I would like to see that sort of thing be a felony. Right now, it's very hard to fit it into a legal theory. It's challenging, and even when you do, it's not. It's not a felony. It's a misdemeanor. And I just would like to see more accountability to the people who would exploit the most vulnerable of our community.
Thank you. I think that's an incredible wish list. Delegate Carol Foy, what's on your wish list for the next session?
Oh my gosh, it's so much. I think everything that Parissa just named, some of the things that come to mind also would be more options for judges to do deferred dispositions, otherwise known as first offender programs. There's this decision called STARS that a lot of judges in different jurisdictions says ties their hands from being able to allow deferred dispositions or first offender programs for a particular type of charges. So I'd like to see that expanded. I know very shocking to me that started practicing in Prince William County that I had a client, she was 18 years old, had no criminal history, never been in trouble, and she took something as nominal as a t-shirt out of a store, and the practice in Prince William County was mandatory 1 day in jail. And on a case-by-case basis, there was no program. And so making sure that we do away with that type of practice here in Virginia is important. Also, getting rid of our 3 strike laws here in Virginia. So, for example, if you have a client who takes a stick of gum and then a year later takes some underwear, and then 4, 5, 20 years later, right, takes a soda, that person is now a felon in Virginia. And so changing those type of laws is important because, again, it's about the punishment fitting the crime. Saying avoid accountability or responsibility, we're saying that it has to make sense. And so getting rid of 3 strike laws does make sense for our criminal justice system. It makes it more fair and more equitable. And so, again, I think doing things like that will help trend down mass incarceration, and also passing my cash bail bill. My cash bail bill mandated data collection because I think it will show up the information we already know, that the poorest Virginians fall into our criminal justice system, women, minorities, and really having that data to make evidence-based decisions about how we want to move forward and particularly reform cash bail in Virginia is important. And so unfortunately, it was not successful the past 2 sessions. And so hopefully this next section, it will, because we have a mass incarceration problem in Virginia because the majority of people being held are being held pre-trial, meaning they have not been found guilty of anything. And oftentimes it's exacerbated because we have a 2-tier criminal justice system here in Virginia, one for the wealthy and one for the poor. And if you're wealthy, you can buy yourself out of jail, while poor clients sit there for weeks and months at a time without being found guilty of a thing. And so that's problematic. That's an issue. And as both former public defenders, Parissa and I, we appreciate that. And we've seen these problems up close and personal. And we see these inequities and how they fester and linger. And it's a problem. And clients tend to take plea deals more often than not, even if they're not good plea deals when they're held pre-trial. Because, oftentimes those collateral consequences that Parissa was talking about, losing your job, losing your housing, sometimes losing your kids, they play a part in whether or not you spend another day in jail and whether or not you do whatever you can, give your left arm in order to get out. And if that means pleading guilty to a crime you didn't commit or accepting a punishment you don't deserve, that oftentimes happens. So I like to see all of these things done and have a long laundry list of bills I'm potentially bring for the next session to really have a fair and equitable criminal justice system.
Awesome. I think that's an incredible wish list, and I look forward to seeing these bills come to life. It looks like we got time for one question. So I'm going to read one of them. When a person with mental illness is suffering from a breakdown, has the police called on them, they're directed to treatment. But if they refuse, because honestly, many of these treatment centers aren't amazing and they have to find an available bed, often there aren't enough available for them to actually be admitted. They are still taken to jail for the night. Is there work towards a better solution than this?
You want me to go first?
Or,
Okay, so there's this thing called a warrantless ECO, which is an emergency custody order, where officers can take a person who's having a mental health emergency and on their own accord, right, themselves, without having intervention of a Commonwealth attorney or a judge or a magistrate, take that person into basically custody. Well, they do have to petition before a magistrate, but they don't have to have a magistrate petition beforehand to take them into custody, to take them to the magistrate, to say this person is presenting with mental illness. I think they need services. The magistrate will make a determination and can issue a warrantless ECO. Oftentimes, officers immediately take the potential clients or defendants straight to the hospital and then come get an emergency custody order after the person has already been taken to the hospital because they're in such need of services. So it's not being widely used in Virginia, and that's mainly because from what I've heard from many officers when I was a magistrate judge in Richmond, is that they don't want to sit on a person for 5, 6, 7 hours before they are actually committed, and then they go into the custody of the sheriffs. So that's an officer's entire potential, hours, patrolling that's taken up with this one client when they're responding to other emergencies. So it's a time issue. It is a money issue, but that is something that officers can do on their own accord, and then get the petition for the emergency custody order to divert people without them even having to come really into the criminal justice system.
awesome. Thank you. Pris, I kind of want to open it up to you. What does the situation look like in Arlington? Is there work towards a better solution?
There is. So in Arlington, we have the emergency orders, but we also, officers can also take individuals straight to the Department of Human Services, to a crisis center that they have. But I am working with the Department of Human Services to try to come up with better solutions. We need more funding for mental health. I mean, if there aren't beds locally, that is a huge problem. I've been willing to release somebody, to agree to somebody's release in a bed-to-bed transfer. So when somebody did spend a night or two in jail, but was mentally ill, I've supported that. But if there's no bed to transfer them to, it's not good for anybody. So we need to invest in our mental health system and improving the institutions that we have, but also making sure that we have room for people.
Awesome. Commonwealth Attorney Tafty, Delegate Carol Foy, thank you so much for joining us tonight. This has been an incredible discussion despite the tech issues. And thank you, viewers, for joining us tonight for our COVID and criminal justice. That's all for tonight, and we'll catch you at the next town hall. Thank you, everyone.
Thank you.
Thank you so much. Bye.